Under the Administrative Procedure Act, or APA, a court has the power to set aside agency action that's arbitrary. Is agency action arbitrary if it imposes a burdensome requirement unrelated to Congress's goals? That's the question in National Tire Dealers and Retreaders Association versus Brinegar. In the National Traffic and Motor Vehicle Safety Act of 1966, Congress gave the Department of Transportation authority to establish motor vehicle safety standards. Using this authority, the agency proposed a safety regulation for retreaded tires. Retreaded tires are refurbished. A manufacturer has taken a used tire and replaced the worn tread. The regulation required labeling retreaded tires with 7 pieces of information, including maximum inflation pressure and load, number of plies, and other characteristics. The information had to be permanently molded onto the tire. The regulation went beyond what Congress had mandated in the Act, namely permanent labeling with ply and load information. The agency used informal rulemaking procedures, including soliciting public comment. The National Tire Dealers and Retreaders Association, which we'll call National Tire, complained that permanent labeling was burdensome. Because each tire undergoing retreading had different characteristics, automation wasn't possible. Workers would have to mold unique labels on each tire using hand tools, increasing production costs by 30%. This evidence became part of the agency's record. However, the agency concluded that permanent labeling was practicable and implemented the regulation. National Tire petitioned for judicial review, naming Transportation Secretary Claude Brinegar as the defendant. The D.C. Circuit reviewed whether the regulation was arbitrary under the APA.